Sir, can you tell me your name, please?
My name is Jennifer Riegler.
Oh, I'm sorry. Ms. Riegler, what case are you signing in on?
It's a conviction set aside for you.
Do you have a case number? Because I don't have you on my docket today.
When I called your secretary back in November, she put me on it, but she never took my name. Get the case number.
Yeah, please.
03-002375-FH-M.
Let's sit here. 3420. Oh, yeah, that's too big. Huh. And I don't think she's on my docket though either. But she is in the system. I do have her file for 130.
I'm going to just put you on hold for 1 second. We're going to pull your file and I'm going to see if I can get this addressed for you today, okay?
Yes, thank you.
Okay.
I do have her file.
Okay, council, let's go on the record in Smith versus Northland Food Center. This is file number 2414577. If I could just have both council put your appearances on.
Your Honor, this is Stephen Boringer here on behalf of the plaintiff, Charles Smith. And Your Honor, for whatever reason, I'm probably only catching every other word. I'm not sure if that's just my connection.
Okay.
Your Honor, Mark
Mr.
Mueller
Mueller?
on behalf of the defendants, and I can hear Your Honor clearly.
Okay. So, Mr. Boringer, that might be a matter with your connection. If Mr. Mueller is able to hear me, okay. So we're on the record here today for purposes of a scheduling conference. And Mr. Boringer, on behalf of the plaintiffs, can you just kind of tell me, what you're looking for in terms of scheduling dates going forward?
You're muted, Steve. If you're having issues, I can fill the court in.
Your Honor, I should have them okay now. I just switched to my cell phone from my actual computer. So hopefully you guys can hear me okay?
Yes.
I can.
Okay. Your Honor, I think we're looking for about 150 days of discovery. There will be one defendant being stipulated to be dismissed from the case. That is Northland Food Center, leaving the two remaining defendants. And there will not be another party added.
Okay, Mr. Mueller?
That's correct, Your Honor. Mr. Boringer and I spoke not too long ago, and he's agreed to dismiss Northland Food Center. That's actually a similar named entity owned by defendant Ronald Ascione, but it happens to be located in the town of Kingsley. This accident happened at the Northland Food Family Center in Kalkaska. We've agreed to 150 days and agreed to mediation and have selected mediator Matt Coffey.
Okay. All right. Is there any objection to setting a mediation cutoff for 180 days, so 30 days following the close of discovery?
No objection.
No objection on my end either.
Okay. Okay. And then let's see. Any objection to a dispositive motion cutoff at about 180 days as well?
No objection.
None for me either.
Okay. All right, and then what I would do typically, and I think in this case as well, is set a status conference for about that 180-day mark. If there haven't been any dispositive motions filed, or if the matter is settled, then we can address it at that time. If not, then we can set further scheduling depending on where the parties are at. Mr. Berenger, any objection to that?
No, Your Honor.
Mr. Mueller?
No, Your Honor.
Okay, I will put those dates into an order. I will also send out a notice of the date and time of that next status conference in about 6 months. Are there any other dates that I can address for either of you while we're on the record here today?
I don't think so, Your Honor, other than at that status conference. Is that when a trial date would be assigned if the case had not been resolved at that point?
Yeah, I usually confer with counsel. Sometimes, parties want to engage in some further ADR before we set trial dates. So we can, it's a date for us to check in. If it looks like trial is where we're headed, we can set trial dates at that time, certainly.
Very good. Thank you.
Okay, I will get that out to both of you, and you're both free to disconnect. Thank you.
All right. Thank you very much.
Your Honor. Just one more question. Will the court advise Mr. Coffey of his selection, or are the parties required to do that?
No, we will send Mr. Coffey notice of his selection. Is he on our this court's approved list of mediators, or did you guys come up with that outside of that?
That's a good question, Your Honor. I haven't looked at Kalkaska's in a long time. I know he's used frequently.
Okay, I would just ask that one of you just submit a letter to the court with Mr. Coffey listed as your selection of mediator, so that my assistant has the spelling and everything of Mr. Coffey's name, and then she will notify him.
Okay, we'll do that, Your Honor. Thank you.
Very good. Thank you.
Okay, sounds good. Thank you.
Thanks, Judge. Thanks, Steve.
You too.
I'm sorry, I see what happened. It still shows Judge Murphy in the case, so it didn't show up on your docket.
Set aside.
Yeah.
Can you let Ryan's office know?
Oh, yeah.
Short notice, but he wants to take a look at it.
All right, I'll let him know.
So Ms. Riegler, I'm still working on it. I did get your file. I see that you did file all the appropriate documentation. I'm just asking the prosecutor's office to join in the hearing because they have the right to comment on your relief requested. The problem was in the computer system, the previous judge that presided over your case, Judge Murphy, passed away, and all of those were supposed to be assigned to my docket. For some reason, the computer did not reassign your case to my docket, so it didn't show up for today, but we can certainly take care of it.
Okay.
If you can wait maybe just another 5 minutes or so, and we can get going on your case.
Yes, thank you.
Okay, thanks. Okay, Mr. Elhart, are you there? Ms. Pop, are you able to hear me okay?
Yes, Your Honor.
Okay, oh, there's Mr. Elhart. All right, good. So we'll go on the record in Tanner versus Tanner. This is file number 2414557. The record should reflect both counsel are connected by Zoom for this status conference today. Ms. Pop, on behalf of plaintiff, can you tell me where things are at from your side?
Yes, Your Honor, we are scheduled to go back to mediation on April 22nd.
So from your standpoint, you want to just set this for a status conference in May? If the matter settles, we could use that time for taking proofs and entering the judgment.
Yes, Your Honor.
Okay. Mr. Elhart, do you have any objection to that?
No, Your Honor, that's amenable.
Okay, so I will set this for a status conference pro-con in May. The court will send out notice of the date and time of that hearing. Ms. Pop, anything else I can address for your side today?
No, Your Honor, thank you.
Mr. Elhart?
No, Your Honor, thank you. Stay safe, everyone. Thank you for your time today, Your Honor.
Thank you. All counsel are free to disconnect.
Thank you.
Did you want a chance to look at that file?
I don't have a file on it, Your Honor, just
It's old, it's from 2003.
if the court doesn't mind.
Yeah.
Thank you.
Thanks. Sorry for the shortness.
It's all right.
I'm gonna take one other hearing and then I'll call that one. Okay. Okay, ma'am, are you Abigail McNitt?
I am.
Okay, so we're on the record now in McNitt versus Brigham. This is file number 2414661. Record should reflect that Ms. McNitt is present today by Zoom video. This was set for 1:45. It's now 2 o'clock. Mr. Brigham is not present. I would also note that Mr. Brigham did not file any kind of answer to the complaint in this case for divorce. And he was served with it personally back in December. So Ms. McNitt, did you still want to go forward with your divorce case?
I do.
Okay, so I can set this for a final hearing date. There's one more form that you're going to need to fill out and get to the court prior to that date. It's called a judgment of divorce. Do you know if you have that?
I do not.
Okay. Where did you get your forms to file for divorce in this case?
At the courthouse, I believe. It's like the one
Okay.
kind of by where the dog shelter is.
Yeah. Do they have the judgment forms?
There should be in her remaining documents.
Okay. Did you get like a whole packet?
I don't quite recall. I'm sorry.
Okay, if
I'm
you did
sure
get a
I did.
packet- Yeah, it should be in there with that packet.
What is it
and
called?
It's called a judgment of divorce.
Divorce. Okay.
Do you see it?
No, I'll have to look for it. I'm sorry.
Okay, that's fine. You can get a copy of it here at the clerk's office. You can also find it online if you go online. But that's the form that I need to sign to finalize your divorce. So I'll need you to fill that out and bring that to the clerk's office before the next hearing date, which I will send to you in the mail.
Okay.
So as long as you fill out that form and get that here before your next hearing, then I can finalize your divorce on that date. If you don't do it, then we're just gonna have to reschedule again. So it's an important step for you to follow through on, okay?
Yes.
And then on that date, we'll finalize things. It'll probably be in about 30 days, so beginning of April. And again, I will send you notice of the date and time of that hearing. It'll be by Zoom like we're doing today.
Okay.
Do you have any questions at all?
No, that pretty much covers it.
Okay, thanks. That's all for today, and you're free to disconnect at this time.
Thank you.
Okay, we'll go on the record now. This is file number 032375. The record should reflect that Jennifer Riegler is present by Zoom video. I do have the prosecuting attorney present here in the courtroom. And so, Ms. Riegler, you've asked the court to set aside a prior conviction that you have from 2003. Is that correct?
Yes,
And that's 2 convictions for forgery that were entered against you back in July of 2003. Is that correct?
yes, it is.
Okay. The record should reflect that the court is in receipt of an application to set aside that conviction along with Ms. Riegler's criminal history. I don't believe shows any other convictions since that time. A letter from the Attorney General's office indicating, and Mr. Ziegler, if you want to address this further, that Ms. Riegler would only be eligible to have one of those set aside. Is that correct?
Your Honor, if that's the position of the Attorney General, that's my position as well.
Okay. So did you get that letter from the Attorney General's office, Ms. Riegler?
I did, yes, but I did not see that part in it. There was only one of them.
Yeah, so the Attorney General's office is indicating that because you have 2 convictions that are each punishable by more than 10 years. And did you have 2 separate convictions, or was it one conviction?
It was just the one, and I got the 2 felonies out of it.
So there was one instance, but there were 2 convictions.
Yeah,
2
It
charges.
was, yeah, I had 5 of them, and the plea was down to 2 of them.
Okay.
So it was in the
So
same case.
yeah, so under the statute, you can only have 1 felony conviction set aside for the same offense if it's punishable by more than 10 years. And these 2 were, which means that you can have one of those 2 convictions set aside, but not both of them.
Okay.
So with that in mind, did you still want to ask to have one of those set aside?
Yes, I do, please.
Okay. So the other 2 criteria that the court has to find or met are that your behavior and circumstances since the conviction would warrant having it set aside, and that it would be in the public interest to do that. So can you just tell me kind of what you've done since 2003 generally, and whether or not you've had any other it doesn't look like you've had any other convictions, but any other involvement with law enforcement since then?
I believe one traffic ticket. I can't remember the year. It was still while I was on probation during that time, and that would be it. I've held the, I'm going on 20 years at the same job. I've stayed local in the community. I've raised my stepdaughter since they were 8 and 10 years old, and they're gonna be 24 and 26. I've never, I've never gotten in trouble or been running with the wrong crowd. That's what happened back in 2003. And I learned from that, them people, they're just the wrong people to be around. And it's not what I wanted for my life and my future. And after jail, it was something I never wanted to experience ever again in my life. And I haven't. And it's just
Okay,
important to me to get the felonies taken away because I have 2 nephews and I have 5 great nephews that are into hunting and getting BB guns. And that's something they're very respectful around me with. It's just something I would like to be a part of their life when they're going through all this. So that's the biggest reason about getting them taken away. So I don't have to ask my nephews to keep their guns put up when I'm around and because they have open carry. So other than that, I haven't ran into any issues at all having them.
okay, and that was gonna be my next question, whether there were things that you wanted to do, but you haven't been able to do based on the convictions, and I think you kind of answered that for me. So, thank you. Mr. Ziegler, people take any position here?
Your Honor, I'm satisfied that the technical requirements for setting aside one felony have been met. I'm also satisfied that Ms. Riegler has demonstrated a change in circumstance and that setting aside one of those convictions would be in her interest and in the public's interest.
Okay, thank you. So Ms. Riegler, again, and I was just double checking your file as you were talking here, and it does look like the 2 convictions were for the exact same offense, which is a violation of MCL 750.248. So it looks like you would not be eligible to have both set aside. I do find that there are proper grounds to have one of those set aside. And so the court will grant your petition to the extent that it can. There is one more form that you need to file. Where did you get your form for your application to set aside the convictions?
From the clerk's office.
Okay,
I
so
gotta-
there's another form called an order to set aside the conviction.
Okay.
You can get that online. If you can submit that to the court and the court will sign that, and that will have the effect of having one of your convictions set aside.
Okay.
Did you have any questions at all?
Nope. So that other felony, no matter what, cannot be taken off my record for the rest of my life.
Yeah, unless there's a change to the statute, which, you know, there have been a lot of changes in the law that have allowed and made it easier for convictions to be set aside. But as of now, the statute provides that if you have 2 convictions for the same offense and they're punishable by more than 10 years, which your convictions were each punishable by up to 14 years, you can only have one of those set aside. So as the law stands now, yeah, there only one can be set aside, but that may change. So I would encourage you to follow the news and follow what happens to the extent that someday that might be different.
Okay. Thank you so much.
Okay, thank you. You're free to disconnect at this time.
Thank you.
Thank you, Your Honor.
Yes, thanks for the short notice
No problem.
appearance.
Christie, you want to last behind? Sure.
What's that file?
For Riegler?
Or just, can you give me the
03 2375 FH.
Oh, 32375.
Correct, FH.
Okay, so I just added this to the schedule viewer for the record. The previous about 10 minutes were a case that was a case that I had to add to the docket. People versus Jennifer Riegler, file number 032375. So again, the previous about 10 minutes have been on that file. Okay, looks like we have both parties connected. We'll go on the record in Helmka versus Hess. This is file number 24-14646. And Mr. Helmka, are you able to hear me okay?
Yes, I can. Thank you.
And Ms. Hess, are you able to hear me?
Yes, I am.
Okay. I have this set for entry of a judgment of divorce today. Mr. Helmka, is that how you wanted to go forward?
Yes, Your Honor.
And Ms. Hess, is that how you wanted to proceed as well?
Yes, sir.
Okay. All right, I'm going to place both of you under oath. I've got some questions that I need to ask each of you. The questions that I'm going to be asking are those that I'm required to ask to establish the grounds for divorce under Michigan law. So if you both would raise your right hands, please. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Yes, Your Honor.
Thank you. You can lower your hand. Mr. Helmka, you filed the complaint for divorce in this case. Is that true?
Yes, Your Honor.
At the time that you filed the complaint for divorce, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Kalkaska County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony had been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed the complaint?
Yes, Your Honor.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
As part of the judgment of divorce, you are not going to be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes.
Do you agree that you and Ms. Hess have divided up any assets or debts and that there remains no issues left for the court to decide?
Nothing other than what was stated beforehand. We just need the judgment to move forward on.
Do you own any real estate together or real property?
No.
All right. Miss, and when you say other than what we said beforehand, what can you tell me what you're referring to there?
The car and our land contract.
Okay, is that something that you guys have already decided on, or do you need that? Is that something that you want in the judgment of divorce because it's not on the form that you filled out?
Okay, yeah, I thought because I was going to write that in. They told me that that was for you to fill out. So,
Okay. Okay, all right.
because I thought it was already record that we had already, I was taking on all debts, etc.
Yep, we did discuss that, but if you want that to be part of the divorce, it needs to be on the actual written document. So tell me again, the land contract, are you both listed as parties to the land contract?
Yep.
So you broke up there. Can you tell me that again?
Yes, that is the case.
So you both signed that contract?
Yes.
Okay, and who is going to be responsible for that going forward?
That would be me.
Okay. And is that for a private residence? Is that a home? What is that?
It's a land contract for land, undeveloped land.
Undeveloped land. Okay. Does it have an address?
Yes, it does.
Can you tell me the address?
Yep, that would be 2292 West Sharon, Southwest, South Boardman, 49680.
Okay. Okay, and then tell me about the vehicle again. Who's going to be taking that over?
That would be me.
Okay, and what kind of vehicle is it?
It's a 2011 Chevy Cruze.
Okay, and does it have a loan on it?
Yes, it does, through Forefront.
And is that loan in both of your names?
Yes,
Okay, but you're going to assume that debt?
yes,
Okay. And Ms. Hess, are you agreeing to both of those things?
Yes, I am.
Okay. And that was a 2011, what was that, Mr. Helmka?
Chevy Cruze.
Are you going to refinance that with the bank in your name?
Yes,
Okay. Okay. All right, thank you. Ms. Hess, have you heard all the questions that I asked Mr. Helmka today?
Yes,
Have you heard all of his answers?
yes.
Do you have any reason to believe that any of the answers he gave were untrue?
No, I do. No, I don't. I don't have any reason to believe any of them were untrue.
Are you currently pregnant?
No, I am not.
You understand that you will not be receiving any alimony or spousal support as part of the divorce. You also will be waiving that forever and cannot come back later and ask the court for that. Do you understand that?
Yes, I do.
Are you asking to have your last? Oh, no, you're not. Okay. You don't have the same last name. All right. Okay, the court finds that the statutory grounds for divorce have been met by the testimony of the parties. The court will grant the divorce. I have written into the judgment the terms that were outlined by the parties for the land contract and the vehicle. And I've signed that judgment. If either of you need a copy of that for your records, you can get that here at the courthouse in Kalkaska. But your divorce is final as of right now. Mr. Helmka, do you have any questions at all?
not at all. Thank you, Your Honor.
Ms. Hess, do you have any questions?
No, I do not. Thank you.
Okay, thank you. That's all for today. You're both free to disconnect at this time. Sorry, council, somebody pressed the wrong button on the microphone here, and I don't have a clerk in the courtroom, so I gotta do everything myself here right now.
I think that-
Okay, so
I think that might
are you
have
guys
been
able
me.
to? Can you guys hear me okay now?
Yes.
I can, Your Honor. Can you hear me? I've been having issues as well. I hope you can hear me well.
Yep, we're good. Okay. So we'll go on the record now. This is Dan Woods Properties versus Dobson, case number 2013517. If I can just have counsel put your appearances on, please.
Good afternoon, Your Honor. Sean O'Mara on behalf of plaintiffs.
Lance Sorhoff on behalf of defendants, counter plaintiffs.
Okay, so we're on the record today. We've got some kind of cross motions for summary disposition that have been filed. I did have a chance, Mr. O'Mara, I did receive your motion and your reply brief. Mr. Zuroff, I did not get my office is in Gaylord. I didn't get a judge's copy of your motion and your response to Mr. O'Mara's motion. So the first time I saw it was at lunchtime today when I had a chance to look at the file.
Really?
So I've not had a chance to, review your position other than just a cursory reading of it. So I don't really want to go forward with oral argument today, not having had a chance to read the briefs and understanding the competing position here. So I would like to reset this for hearing on next month's motion day. So Mr. Zuroff, I guess I would just ask Mr. O'Mara, I mean, your motion's already been noticed for hearing today, but Mr. Zuroff, it looks like you're asking for the court to grant summary disposition under I-2, but you've also filed a separate motion, but they look like they were the same. Is that right?
They're identical. So I do that as a courtesy to the extent the court feels, whenever I request I-2 relief, I also notice it up as a standard summary disposition motion under whatever it is, C8 or C10, depending on what the motion is based on. And I just do that as a courtesy to the extent the court wants more time to consider the argument. So I do that as a matter of course, usually. So I did get a separate date for, to be heard. I think it was April 8th. I don't know if you have a standard date that you usually have, summary disposition on up here in this court in Kalkaska, but.
Okay, so you already have that notice for April.
Well,
I believe it's, is that right?
I didn't see a notice. I didn't actually see a notice for your C8 or C10 portion.
Okay.
So
let me check with my assistant on that, because I know she got a date and I don't know if it got noticed or not. So
I don't have one. I don't have one. Maybe it was, I don't know, but I didn't see that, or I wouldn't have objected to it being heard. My issue is the timing of it, but no, but the facts don't change here. And Your Honor, if you need time, that's fine. Nothing's going to change in terms of the facts. Whatever day will work for you, Your Honor, I'm okay with it.
So could I ask so that this doesn't happen in the future? So where did my response go that it didn't end up getting to you until now? Because I think I filed it to be safe. I filed it 9 days as a response before the hearing date, and I don't know where it was sent because I don't, I rely on my assistant to do that. So where should it go to make sure that it gets to you in a timely manner?
So your response was timely filed with the court file here in Kalkaska County, which is correct. The problem is, I have a 3-county circuit, so I'm not always here in Kalkaska, and my office is in Otsego County. So when motions and briefs get filed, the file copy has to go to Kalkaska, of course, because that's where the file is, but then I need a separate judge's copy sent to Otsego County. So your motion or your response was properly filed and was timely and was in the court file just like it should have been. The issue was I don't know that because I'm in Otsego County, and so I rely on counsel to file judge's copies with my office in Otsego County so that I know, that there's a response. So for instance, I mean, like I said, I got Mr. O'Mara's judge's copies were sent to Otsego County, and the file copies were filed here in Kalkaska. So I had his things, and I always, assume that somebody's not going to just agree to a motion for summary disposition, but without a brief, a judge's copy, I don't know what the response is. So like I said, the first I saw, Mr. Zaroff, of yours was by looking in the actual physical file when I got here to Kalkaska today. Okay. So that's a long answer to a short question, which is file copy to the county where it's filed, and a judge's copy to my office in Gaylord.
All right.
So if you can do that, so that I don't have to drag all 4 volumes or 3 volumes of this file back to Gaylord with me, if you can file a judge's copy of what you've already filed with the court file, Mr. Zaroff.
Okay. Yeah, I'll do that.
And then I'll ask that you, Mr. Zaroff, just follow through and notice up your motion for hearing, and then we'll hear Mr. O'Mara's motion as well. In April, we'll hear them all together, and by that time I'll have copies of everything that I need, and we can get a ruling on the record that day.
Okay. Do you know if that does April 8th sound like a date where it's usually? Yeah.
It does. Yeah, my motion day here in Kalkaska is the first Tuesday of the first full week of the month. So that sounds, April 8th sounds right.
I just have a conflict. I have a 1 o'clock in person. Would it be at 3:15 on April 8th?
It is.
I'm not sure.
Yeah, I just looked at my calendar, my electronic calendar, and that's what's on my calendar. So we must have that date and that time from the court. So
I didn't have it. I would have put it in, but is there another day? Just a week? Can we do the 15th? I can make it work on the 8th. I hate being double booked. I really do.
Yeah, I mean, if you guys want to try to confer and get a date from my office, the problem, Mr. O'Mara, is so 1 week of the month I travel between the 3 counties for motions and those types of things. And then the other 3 weeks I have trial in each county. So the 15th is going to be a trial date for me in Crawford County, probably.
Okay. Okay. I'll make it
but
work.
Occasionally there's openings in there. So if the 2 of you want to come up with a date that works for the 2 of you, or a couple dates, and then call my office to see if any of those work, then I can try.
I'll plug it in for now for the 8th at 3:15.
Okay.
Okay.
And I'll send a judge's copy, correct, to Otsego County, so you have that with a notice of hearing. It'll either be April 8th at 3:15 or some other date or time that Sean and I can agree to. That's open for the court. Okay.
Yep. Perfect. Okay. All right. Thanks. You're both free to disconnect at this time.
All right.
Thank you.
Thank you, Judge. Have a great day.
Okay, looks like I think we have everybody connected, so we'll go on the record. This is Antea versus Munson and various defendants. This is file number 2213998. Ms. Peacock, you're here on behalf of plaintiffs, is that correct?
Yes, Your Honor, thank you.
Do you have co-counsel? Because I guess I thought I'd have 5 attorneys and I've got 6 connected. So I'm just trying to figure out where we've got somebody doubled up here.
I think that's on our end, Judge. I'm going to be arguing the motion today. I'm here on behalf of Sound Inpatient Physicians. And Connor Morgan from our office is also here. He's going to be observing.
Okay, great. Sounds good. Mr. Artea, can you put on your appearance?
Yes, Your Honor. Nick Arteev on behalf of the Munson defendants, Munson Healthcare, Munson Medical Center.
Mr. Thomas?
Good afternoon, Your Honor. May it please the court, Matt Thomas. I'm here on behalf of nurse practitioner Schulich, Dr. Craven, and Kalkaska Memorial.
Thank you. And Mr. Martin?
Good afternoon, Your Honor. Jonathan Martin, appearing for Elizabeth Szymanski, MD, and Northwestern Michigan Emergency Physicians, PC.
All right, thank you. We're here on the record today for essentially motions for summary disposition as to 3 of the groups of the defendants. Mr. Thomas, correct me if I'm wrong, but your clients are not the subject of the motion today. Is that correct?
We did not file a motion that's up today. Correct, Judge?
Oh, okay, great. So I don't know, and I should let the parties know, I did have a chance to review all the motions, plaintiff's responses, and the replies that were filed to that. I've spent a lot of time going through the depositions and all the records that were submitted as support for the motions and the responses. So I'm really well familiar with the arguments of the parties and the underlying basis in terms of the evidentiary support for each side's position here. And, you know, from my view, and I'll allow counsel, of course, to the extent that this is more nuanced than I'm presenting it here. But the Munson defendants, Sound Inpatient, Wells, Hunter, Szymanski, and the Northwest Michigan emergency room physicians, all those defendants, seems to me, are making essentially the same argument under C10 with regard to causation, or a similar argument at least. And so I'm not sure how you all want to proceed with oral argument. If any of you have had a chance to discuss how you wanted to do that today. I believe the first motion I got was the Munson defendants from Mr. Arteev. So I guess I'll just start with you, Mr. Arteev, and then I'll let the other 2 counsel for the other defendants kind of fill in the blanks, or I guess tell me where their motions are different or more nuanced than Mr. Arteev. So Mr. Arteev, if you want to go ahead and proceed with oral argument.
Thank you, Your Honor. And I think that makes the most sense just because I think our motion encompasses everyone's arguments essentially, basically anyone that treated Miss Antaya at Munson Medical Center. So that would include Miss Doyle and Mr. Martin's clients as well. Your Honor, I understand you've already read the brief, so I'll try and kind of hit on some of the more main points that we're arguing here just to emphasize that for the record. But our argument essentially is that plaintiff is going to be unable to establish a genuine issue of fact at trial for a jury related to connecting any of the alleged breaches in the standard of care by any of the providers at Munson as being the cause of Miss Antaya's current neurological injuries or damages. In this case, essentially, Miss Antaya is claiming that she required earlier decompressive surgery in order to have a better outcome from her cervical spine injury. And prior to that decompressive surgery, she would have needed to undergo an MRI. The allegations specifically against the Munson providers are that they didn't do enough to ensure that she underwent that MRI at an earlier time. And as evidenced by our briefing and specifically the timelines that we highlight on page 17 in our brief and 18, even when looking in the light most favorable to the plaintiffs, it's evident that Miss Antaya's die was already cast by the time she arrived at Munson Medical Center. And specifically, that we're relying on the deposition testimony of their spinal surgery expert and their causation expert, John Tidings, and specifically Dr. Tidings opined that in order for Miss Antaya to have a different outcome, essentially her surgery needed to be completed by 5 p.m. And he bases that on a note that was documented about 6 p.m. that noted complete neurological injury. And based on the undisputed timeline that we've presented in our brief as to all those things that Miss Antaya needed to undergo prior to having that decompressive surgery completed, it's evident that Miss Antaya couldn't have possibly had her surgery completed before 5 p.m. or 6 p.m. And importantly, it's also undisputed that Miss Antaya really needed to undergo several different steps before she had that decompressive surgery done, like having the MRI actually ordered, undergoing the MRI, having a neurosurgical consult, and obviously it takes some time to actually complete the surgery. And plaintiffs don't dispute that particular timeline. And as we point out on page 17, essentially, even when we're looking at in the light most favorable to the plaintiff, meaning that the MRI starts right at the time the MRI room is notified she's ready to undergo the MRI, that surgery won't be done by 5 p.m. or 6 p.m. And the earliest it would have been done was approximately 7:50 p.m. Even more importantly, Your Honor, I think it's also important to emphasize that plaintiffs don't meet their burden of proof by simply saying it was possible for the MRI or for the decompressive surgery to be done by 5 p.m. or 6 p.m. They need to also prove that that injury is rooted in some sort of breach in the standard of care. So even more fatal to plaintiff's case in this situation, their own standard of care experts acknowledge that there is going to be naturally some sort of waiting period between the time the MRI is ordered and undergoing the MRI. And they say, the nursing expert says, about a 1-2 hour wait. And their emergency medicine expert says that it's acceptable for there to be a 3-hour wait. And we've presented those other timelines as well in our brief on page 18 that again highlight that based on an alleged breach in the standard of care and based on that undisputed timeline, that surgery still isn't getting done by 5 p.m. or 6 p.m. And finally, Your Honor, I think most notably when looking at plaintiff's response, they don't argue that the decompressive surgery could have been done by 5 p.m. or 6 p.m. based on the time Miss Antaya actually arrived at Munson Medical Center, which was around 1:30 p.m. Instead, they say, well, it could have been done, but only if she was transferred from Kalkaska to Munson at an earlier time. And importantly, Your Honor, there's no allegations and there's no evidence saying that anyone at Munson controlled that transfer process or had any control over the decision of when to transfer Miss Antaya to Munson. So, Your Honor, I think this is one of those situations where summary disposition is appropriate because essentially the jury is not going to be able to cling on to any sort of fact or piece of evidence presented by the plaintiff that's going to allow them to conclude that any of those alleged delays in obtaining the MRI at Munson Medical Center would have allowed her to get the surgery done prior to the time that their own causation expert thinks that surgery needed to be done in order to make a difference in her outcome. Thank you.
Okay, thank you. Mr. Martin, anything that you wanted to add on behalf of your clients?
Yes, thank you, Your Honor. I join in and concur in everything that Mr. Arteev said. Dr. Szymanski became involved in the patient's care at about 1:30 p.m. and she wrote the order for the MRI at 2:14 p.m. The plaintiff's expert, the plaintiff's only emergency medicine expert, the only expert that's qualified to testify for plaintiff on behalf of an emergency medicine standards of care, testified that the order entered at 2:14 was within the standard of care. The plaintiff's experts have also admitted that the time of acknowledgement of the order, 2:27 p.m., and the time of the MRI questionnaire being completed at 2:35 p.m. met the standard of care. Dr. Bao, at page 78 of his deposition, said that it would be reasonable to take 3 hours for an MRI to be completed. That's not a breach if it takes 3 hours. So plaintiff's case is based on the fact that there was a 6-hour interval between the time the MRI was ordered and the time it was started. It was ordered at 2:14 p.m. and it was started roughly at 8:15 p.m. So that's a 6-hour delay. Dr. Bao says a 3-hour delay is reasonable. So even if you move the entire timetable up 3 hours, the surgery doesn't get completed until 10:30 p.m., well after the time that Dr. Tidings, plaintiff's only causation expert, says it needed to be done in order to prevent permanent neurological damage. So even if the surgery had been done by 10:30, moving the timeline up 3 hours, it doesn't make any difference. And even if you take the nursing expert's testimony that it should be started within an hour, moving the timeline up 5 hours doesn't get them into that 5 or 6 p.m. time frame either. But that 1 to 2 hour time frame testified by the nursing expert is not applicable to Dr. Szyminski, an emergency medicine physician. So in order to prove proximate cause, plaintiff has to prove more likely than not, if things had been done within the standard of care, the outcome would not have occurred. They can't prove that. They don't even have speculation at this point. So they cannot meet their burden of proof on the issue of causation. And I think plaintiff's response is very telling because it says that, well, she should have arrived at Munson at 9:30, 4 hours earlier, but she didn't. And plaintiff's focus on, well, she should have been sent to Munson earlier, really underscores the reality that the die was cast before she arrived at Munson Medical Center at 1:30 p.m. and before she was even seen by Dr. Szyminski. So for those reasons, we think summary disposition is appropriate. If the court has any questions, I'd be happy to address them.
I do not, thank you. Ms. Doyle, anything on behalf of your clients?
Yes, Judge. As I said, I represent sound inpatient physicians, and that includes PA Wells and Dr. Hunter. I agree with everything that's been said so far with regard to the timelines, but as to my clients, it's even easier. PA Wells did not see Ms. Antaya until after 6 p.m. Her note is written at 6:07 p.m. I believe she was admitted under PA Wells at 5:59 p.m. There is nothing that either PA Wells or Dr. Hunter, who saw her at 6:52 p.m., could have done prior to the permanent injury. As Dr. Tidings alleged, it was permanent by 6 p.m. Recovery of the lower limbs was limited by 5 p.m. My clients weren't involved prior to that time. There's nothing that they could have done that caused this permanent injury.
Okay, thank you. Ms. Peacock, your response?
Yes, Judge, I'm sure as you read in the briefs that this is a case where the combined negligence of the defendants allowed an over 14-hour delay in obtaining an MRI, which was the only study that my client needed to avoid spinal cord compression and have surgery, avoiding the outcome of becoming a paraplegic. As well as the fact that today, as the plaintiff, I am entitled to the evidence in the light most favorable to the plaintiff, and any doubts on the question of proximate cause is for the jury. The timeline regarding how things could have ended up differently if Miss Antaya had gotten to Munson faster due to the alleged negligence of Kalkaska are well laid out in my brief, and I'm not going to go over those again. However, I would like to highlight for the court today that if Miss Antaya had arrived at Munson at the same time, which is 1:30 p.m. on March 19, 2020, the expert testimony in this case does in fact established that she could have been taken to the operating room in a timely manner and had a better chance of recovering, if not having full recovery. On page 39 of his deposition, my causation expert testified within a reasonable degree of medical certainty that if surgery had been done 5 or 6 hours earlier, there was a better chance of recovery. If surgery had been completed 5 hours earlier, that would have been 7:32 p.m. He also testified there was a 12-hour window to get her to surgery and have a recovery. Her onset of symptoms was approximately 7:45 a.m., making surgery having to start by 7:45 p.m. The question thus becomes, in viewing the facts in the light most favorable to plaintiff, could surgery be completed prior to 7:32 p.m. or 7:45 p.m.? And the answer is yes. Miss Antaya arrived at 1:30 p.m. My standard of care testimony, my ED expert, Dr. Baugh, testified that the neurosurgery consult should have been done within the hour. That's 2:30 p.m. We know it took 45 minutes to get Miss Antaya to the MRI suite once the neurosurgeon was consulted. Based on Dr. Tiding's testimony, page 17 of his deposition, the MRI should have taken 1 hour. She gets to the operating room by 5:15 p.m. 6:15, the surgery begins, and Ms. Antaya's spinal cord lesion is decompressed. I would also point out to the courts that the standard is not that she would have avoided complete quadriplegia. It's whether she would have had a better outcome. I think that, you know, having your legs move and your arms move more is certainly a better outcome. And also, I know that he said something different in his deposition, but the surgeon from the defendant hospital certainly wrote in the note that she would have had a better outcome if she had not waited hours and hours and hours for the MRI scans. And I think taking the facts in the light most favorable to plaintiff, that summary disposition should be denied today.
Okay, thank you. I'll give each of the defendants a chance, since it's their motions, to respond. Mr. Arte, have anything you wanted to add?
Your Honor, I think Ms. Peacock's arguments are reflected in a response brief, and we've addressed those in our subsequent reply brief. But I think ultimately, you know, the real focus of this case really should be that we pointed out in our brief that even at 1:30 p.m., she really wouldn't have had that surgery done by 5 or 6 p.m. And really that is really what we're looking at here in this situation. Not to mention, you know, I know Ms. Peacock mentioned that there was maybe reference of a 12-hour window, and now all of a sudden, you know, we're talking about 7:30, 7:45, something like that. But ultimately, Dr. Tidings was asked multiple times in his deposition. We've cited to those pages multiple times that he kept reverting back to the note that P.A. Wells wrote indicating the complete neurological injury. So really, that's the time that we're looking at. And again, on page 17 of our brief, we point out pretty thoroughly that all those things that needed to be done before the decompressive surgery was completed, and all those things are not being criticized as breaches in the standard of care by the plaintiff. All those things took a certain amount of time, about 5 hours and 15 minutes. And ultimately, if we look at the time when the MRI was ordered and add that time, it's clear it's well past that 6 p.m. point. I'll let the other defendants respond as well. But thank you, Your Honor.
Thank you. Mr. Martin?
Yes, Your Honor, thank you. Dr. Tidings says at page 60 and 61 of his deposition that in order for Miss Antaya to be salvageable from a functional standpoint, the die was cast around 6 something. And then he goes on that he talks about the 5 to 6 p.m. timeframe. There was a chance she could have recovered bowel and bladder. Once it was past 6 o'clock, it was now a complete lesion. It's probably more likely than not after that, even with late decompression, she can occasionally see improvement, but it's not as likely. What he's really saying is that by 6 o'clock, more likely than not, she's not going to be salvageable from a functional standpoint. The standard is not if there's a chance for some improvement. The standard is more likely than not. And we shouldn't confuse words like has a chance with a better outcome. Again, the fact that plaintiff argues that she should have arrived at Munson earlier underscores the reality of the testimony of Dr. Tidings on causation, that the die was cast by the time that Ms. Antea arrived at Munson Medical Center at about 1:30 p.m. If the board has any questions, I'd be happy to address them.
Okay, thank you. Ms. Doyle?
Yes, Judge, just briefly. Again, my clients were not involved in the transfer, not involved in the ED care. Plaintiff's response lumps the entire course, including them before she arrived at Munson, together. And it's speculative as to what would have occurred. We have to rely on the facts that are established in this case and the timeline that's set forth, not what would have occurred if she had possibly been transferred earlier.
Okay, all right, thank you. Again, I did go through everything that was presented by the parties in writing. Everybody's arguments here today are consistent with what was presented in the brief, so I do feel comfortable ruling on the motions from the bench here. First of all, with regard to the standard, the motions were brought under 2.116C10. The parties all accurately cited the court rule and the standard, which is number one, the court has to view all the evidence in the light most favorable to the non-moving party, which in this case is the plaintiff. In order to grant a motion for summary disposition under C10, the court has to find that there's no genuine issue of material fact. In this case, each of the different groups of defendants have moved for summary disposition based on a lack of a question of fact as to causation. In other words, that the plaintiffs have not brought forth sufficient evidence to show that that a reasonable jury could conclude that any of the moving defendants were the proximate cause of Ms. Antea's injuries in this case. So viewing the evidence in the light most favorable to the non-moving party, first of all, I did go through the timeline and the court, I understand the defendant's arguments that anything really that happened prior to 1:30 isn't anything that could have been helped by any of the moving defendants here, because that's when Ms. Antea arrived at Munson. And so really the court should start the clock from that time. However, it's clear to me in looking at this case as a whole and the whole course of events that led to Ms. Antea's eventual condition, I don't think it can be chopped up into pieces like that, even though these moving defendants weren't involved in the care prior to 1:30. The court has to take into account the entire timeline, which really began that morning when Ms. Antea started having the symptoms of paralysis and called 911, because that's really the starting time for everything that happened after that. Also, I think that Dr. Tidings, his deposition really has to be read as a whole, certainly, and understandably so. The defendants focused on pointing out his particular testimony, especially in pages 67, 69, and 76 and 77 of his deposition, where he was really being questioned about this kind of 5 o'clock, 6 o'clock time frame. But I think it's important to read his deposition as a whole, where he makes it clear, number one, that the 12, as I read it, the 12 to 24-hour period is really the crucial time for when these types of patients can really start to be in danger of losing function permanently. And so there's that window that I think Dr. Tidings testified to, where if surgery isn't done and there isn't decompression within that period of time, that's when the really bad results start to come in terms of permanent injury. I think it's also really important to know that in Dr. Tidings' testimony, you know, at the beginning when he was being asked to really say, okay, when was the drop dead time here where after that Ms. Antaya is no longer salvageable or is going to have permanent injury? And I thought he was pretty adamant in his testimony that, you know, I can't really give you a specific time. This isn't 1 minute she's okay and 1 minute she's permanently paralyzed. This happens on a continuum throughout the course of the progression of her condition. And I thought he was also very adamant that the earlier that surgery is done and decompression is done, that's when the patient has the best chance of either having a full recovery or the permanent injuries being lessened. And then he also gave some testimony to indicate, you know, even if it's done later, even at the 24-hour mark at the end of when that window is, you still have the surgery because you don't know what the degree of recovery is going to be. And you don't know how much of the deficits that she was showing at that time are the result of a permanent lesion, how much of it is temporary, how much of it is due to, I think he used the term spinal shock, where, you know, the patient is going to recover from some of that at some point. So you still have the surgery because you don't know what the degree of permanent injury is going to be. So I think all of that plays into his opinions regarding this 5 or 6 time frame where he certainly did make those statements and give the testimony pointed out by the defendants. But I think that also has to be looked at in the context of his larger testimony, which is even if it's past that point, you still do it as soon as you possibly can, because that's going to make a difference in what happens to the patient. So looking at it from that perspective, and again, pointing out, you know, defense counsels argued that plaintiffs can't meet their burden. Well, you know, perhaps they won't be able to in terms of a jury verdict. I don't know. But again, this is a motion for summary disposition. The plaintiffs aren't required to prove at this point by a preponderance of the evidence, or more likely than not. The plaintiffs just need to bring forth enough evidence for the court to find that there's a question of material fact. So, you know, I'm not making a decision on the ultimate issue here. Again, the court's viewing this as a C-10 motion. And so based on Dr. Tidings' testimony, and specifically his testimony that, you know, there isn't 1 minute where the patient's okay and the next minute she's paralyzed, that anytime during that window, you're still going to do the surgery. I think it's enough under a C-10 standard to show through his testimony that it's possible that the delay by all of these defendants and the surgery, which didn't take place until 12:32 a.m., and that those delays by this group of moving defendants resulted in that later surgery and resulted in a greater injury to the plaintiff than she would have had they not delayed. I think there is a question of fact, again, looking at this under a C-10 standard. You know, also looking at, you know, there was testimony from several of the experts that, you know, referencing the amount of time the MRI itself took, or the intake part of that took, and saying, okay, all other things being equal, this wasn't an unreasonable amount of time. Again, I think it came through to me in Dr. Tidings' testimony that while in normal circumstances or under normal conditions, none of those things may have been unreasonable. When you're dealing with a patient who's presenting with the symptoms that she was presenting with the possibility of, you know, an abscess or I'm not sure how to pronounce the phlegmon, which is a bacterial infection, that type of thing, when you have a patient presenting with that, you know, you need to get that armor, at least have an initial MRI so that it can be looked at soon to determine, okay, do we need to do surgery right away? And I think that all of that is bolstered by the notes from Dr. Salufo, the surgeon, and where it was clear to me that the surgeon felt that there was an improper delay here and was frustrated with the delay that took place. And all of that, again, looking at that all together, the court finds that there is sufficient evidence on the issue of causation such that there is a question of fact for a jury to decide whether and to what extent the actions of the moving defendants here caused greater injury than would have otherwise resulted. So for those reasons, the court finds that the motion should be denied as to each defendant. And I would just ask counsel maybe to circulate a collective order with a stipulation as to form, just for the reasons stated for the record that the motion's denied. And that's all I have for today. Mr. Arte, have anything further that you needed to address for the record today?
No, Your Honor. I think we were also going to do a status conference based on the outcome of the motion, but I'll leave it up to your discretion whether you want to do that today or at a different time.
I don't have my docket in front of me, but we could certainly address that. Ms. Peacock, on behalf of plaintiff, is there anything, what are your suggestions for going forward in light of the court's rulings here today?
I would report that the parties are working together, but there's a lot of them, and we're still working through expert discovery.
Okay. Again, I've got all the briefs and everything, but I don't have the court file right in front of me. Do we have a cutoff date set for discovery, or is that open right now?
Let me get you that answer. I'm sorry. If anyone else knows the answer, please speak up.
I'm looking.
I don't see a specific date docketed in our file for cutoff of discovery, but I could also be wrong.
I also don't have a specific date on our calendar, so.
Okay. But the parties, again, just addressing Ms. Peacock, since you brought it up, we're still engaging in discovery. The parties are still moving forward with that. Okay, I guess my suggestion, maybe just for purposes of today, is to just have discovery remain open for an additional 90 days. Set a status conference at that 90-day mark, and then see where everybody's at.
Judge, this is Matt Thomas, and I was quiet for so long I can only stay quiet for a period of time. My only, and I appreciate the court's willingness to allow discovery to continue open and setting a status conference for 90 days. My scheduler is about to pull out her hair in this particular case. You know, we've offered up, like, and I'm not joking, for our experts, like 35 or 40 potential dates, and we can't get an agreement. And I'm not suggesting anybody's acting in bad faith. It's just the schedules of 5 very, busy offices and that type of thing. But she actually sent me a message over the weekend. She's like, we started giving dates in January. We now have given almost the entire month of June and we can't get a date. So I'm just concerned that I see, 27 dates that were offered in June and none of them are agreeable, that 90 days is not going to be enough. And that's my only concern. I don't want to delay anything. And again, we've taken a lot of depths in this case, and I think we all get along well. So it's that's not the issue. I'm just really concerned that if we come back in 90 days and we say, Judge, we're still working, I'm fine to come back in 90 days. I just want the court to be aware that might be an issue.
Yeah, and I mean, just to address that, I'm certainly not saying that 90 days would be a hard cutoff. I'm just saying let's keep it open for another 90. That would give me an opportunity to check in with all of you. I just want to make sure that we stay on top of it so that it's just not languishing out there. And that makes me feel comfortable that I'm monitoring the case so that I'm not letting it go too long, which is one of my duties. And then if the parties need more time and everybody agrees that you're all working towards it, then we can do that. So
Fair enough.
does that address that? Okay. Does anybody
Absolutely.
else have an opinion to going forward that way, at least over the next 3 months?
That's fine, Your Honor. I understand your perspective, so.
Okay. All right, so I will send out a notice of the date and time for that status conference in about 90 days. And we'll go forward from there. Thank you, and all counsel are free to disconnect at this time.
Thank you,
Thank you,
Judge.
Judge.
Thank you.